Hi, everybody. Thank you so much for joining today. We'll go ahead and get started on today's webinar brought to you by Alcorn Immigration Law. What to do if you were selected in the H-1B lottery. It is a pleasure to have you here today. And if you're here, it's very exciting news that either yourself or an employee in your team or somebody you've made an offer to has gotten selected. So I'm super excited to answer your questions throughout today's webinar. The primary vehicle I use to do that is the Q&A panel. And I see that some folks have already started putting questions in there. So I'll do my best to answer all questions in the Q&A panel within today's 1-hour webinar. And if you're just joining us, welcome. We're just now getting started with what to do if you were selected in the H-1B lottery. It's one of my favorite times of year because the goddess of good fortune and grace shines upon those who have been lucky enough to get selected. So it's always fun. So this program is being recorded. This is an educational service brought to you by Alcorn Immigration Law. All information we discuss should not be construed as legal advice for any specific action, and it is an overview only. And please be sure to consult a knowledgeable professional for assistance with your particular immigration matter. And that goes for you, whether you're at a company and your company needs legal advice and a business immigration attorney, which of course we're happy to support with, or if you're an individual and you need legal advice for your life. In some circumstances, we're able to help with that as well. But please keep that in mind. Some additional housekeeping. As we go through today's slides, you'll see a QR code in the bottom right, and that is the most expeditious way for you to get in touch with us at Alcorn Immigration Law if you would like to initiate an H-1B for your company or for your beneficiary in this year's H-1B lottery season. And I'll be chatting a lot more in detail about what that looks like, how it works, what that program with Alcorn looks like. And then I often get the question of, oh, I missed part of the recording, can I refer back to it? Of course, my team is going to be sharing the recording of this with everybody who registered in the coming days, but please do, stay with me if you can, if your schedule permits, and then that will allow you to ask your questions, and I can actually focus on providing a real educational, non-legal advice answer to everybody here. But also please keep in mind with the Q&A panel that it is not confidential. If your name, I believe some people can see your name if you put it, so you have the option to ask a question as an anonymous attendee, and that would be the way to do it if you would like to keep your identity confidential. So just, some good things to keep in mind as we move forward. All right, so I'm Sophie Alcorn. I'm the founder of Alcorn Immigration Law. Some of you are founders or early stage technology startups, and I was told yesterday by a founder that we're the world's most founder-friendly immigration law firm, and I really liked that. And I'm, very proud of that. It's something we continually strive towards all the time. To be clear, we help a lot of companies that are not just technology startups. So please, if you have any questions about that, you're welcome to ask here or reach out to my team. But my vision and mission for the firm is to really transcend borders, expand opportunity, and connect the world by practicing compassionate, creative, and cutting-edge immigration law in service of the betterment of humanity. And I believe that when more people can work in their Maslow's hierarchy of needs, self-actualized pinnacle state, that their work will be in a flow state. They'll come up with genius inventions and discoveries and creative things that help move the world forward, whether that means getting the plastic out of our oceans, or helping to reforest where it's needed, or helping us become a multiplanetary species. or helping, people live longer and have healthier lives on planet Earth. All of those things are so exciting for humanity. And so that's one of the things that I've dedicated Alcorn Immigration Law to pursuing. And my background, for any of you who I haven't had the pleasure of meeting yet, my name is Sophie Alcorn. I'm the founder of Alcorn Immigration Law. I have a podcast. It's available on Spotify and Apple Podcasts called the Sophie Alcorn Podcast, where I interview thought leaders in the immigration space on recent policy updates and changes, what the administration is doing, best strategies, how to prepare for your company or for your case. So lots of great resources there. I think over 200 episodes, maybe a lot more. I don't remember. On our website is my 4 years and hundreds of TechCrunch columns that I authored that also are a treasure trove of information on how to navigate the immigration system. And just a little bit about me. I am a mom. I like to meditate, and I believe that every child who is born on our planet should have the opportunity, as I mentioned, to self-actualize so they can follow their hearts and live their dreams and build their dreams. Okay, my team is growing. We're hiring. If there is a special immigration lawyer in your life who might like to work out of our Palo Alto office with me, or even remotely, please refer them to us. I just published several job ads on LinkedIn, and I'm always looking for amazing, proactive experts who also have big hearts and who are focused on compassionate counseling and service to provide our clients with the best experience. Okay, so thank you for being with me for the intro. Let's dive in. And as mentioned, you're welcome to use the anonymous attendee name. This will be recorded. You will receive a copy. I will try to answer all questions in the Q&A panel within this hour. I have several slides that will outline what is going on with H-1Bs and what are your next steps if you got selected. It's so exciting. All right. So first of all, what is all this talk about cap subject, cap not subject? What's an H-1B? Like, mommy, daddy, where do H-1Bs come from? Okay, so immigration laws have been around for decades, like since the 1950s, post-World War II. That's when our modern system kind of started forming, and it had a lot of changes in the 60s and then the 80s and the early 90s, and kind of the system we're using today for business immigration got solidified with the Immigration Act of 1990. So think about it. There were answering machines, fax machines. I don't even think card phones had been invented, but that's the time when our modern immigration system got created 35 years ago. A lot has changed in the world since then. So basically, the statute says every year Congress can give out 85,000 new H-1Bs to professional workers who are being petitioned by companies. And within that, 20,000 of those have been set aside for people who got master's degrees or PhDs from a US nonprofit college or university. And so because there is more demand every government fiscal year than the supply of these 85,000 H-1Bs, that is why the government has turned to a lottery system. So right now we are in government fiscal year 2025, which started last October 1st. So the lottery that happened a year ago had over 470,000 eligible registrants, and it ended up having 4 lottery cycles. So the first one happened in March, then the government, I believe it was last year, it may have been the year before, but they announced anti-fraud measures with making statements under penalty of perjury. And so a lot of the number of applications decreased. And so they actually had multiple lotteries, maybe 4 even, where like they didn't have as many people applying. So if you're in human resources, and if somebody at your company, if their status in USCIS's website still shows that their registration has been submitted or is pending, there likely will be another opportunity for more people to get selected in July after this petition filing period closes on June 30th. And for everybody that we're applying for right now, the earliest possible start date is always October 1st. So this year, for the fiscal year 2026 H-1B cycle, the earliest possible start date for work will be October 1st, 2025. And I'll get more into CapGap and other things of that nature a little bit later. Now, last year, overall, our clients experienced about a 20 to 25% chance of getting selected, regardless of if you had a bachelor's degree or a master's degree. And you can see nationally that the bachelor's degree holders had about a 12% chance of selection, and the master's degree holders had about a 24% chance of selection. Now, we are experiencing a better selection rate this year, which is so exciting, and it's so great to see all of you in the listening there in Zoom land with me today. So thank you for being here, and I'm very excited for you. So we're expecting USCIS to announce the final statistics within the next couple of weeks. They have not yet disclosed this fiscal year's 2026's registration numbers yet, but our estimates are that about 35% of people have been selected, with an even higher percentage for people with master's degrees. So it's very exciting. One possible factor for this could be that this year the fee increase took effect, and so it went from being $10 per registrant to $215 per registrant. So it will be interesting to see how the overall numbers have changed. Although, of course, there are many other political and macroeconomic factors that might have affected the overall selection rate. But anyway, if you're here, you're happy that there were probably fewer people than normal who applied, and you are in this audience. So let's first talk about, understanding what this means with your selection. Okay, so what does it mean if you've been selected? So now USCIS is going through a lottery notification process. There are two groups, as I mentioned, the people with the higher chance of getting selected, which was the advanced degree cap, and then the people with the lower chance of getting selected with the regular cap. They're going to be sending out registration documents that we need to include. And so the ball is in the immigration law firm's court to file the H-1B by June 30th. If you do not, you will lose your chance of getting this H-1B forever. You would have to go through the lottery again and be selected again if the government doesn't receive the full H-1B I-129 petition by June 30th. So right now, the ball is in the employer's court to quickly choose, retain, initiate immigration legal services if they do not yet have an attorney or a law firm. Because some of you on this webinar are working with companies that have been engaged with Alcorn for quite some time, and we helped with your registrations. Sometimes some companies choose to do that process independently, and they might be looking for immigration counsel. So either way, we're here to help, but definitely if you're with a company, time is of the essence, because we would like to know if you need our support sooner rather than later, so we can ensure capacity to be able to support you by this June 30th deadline. Now, I'll make another note regarding the regular cap versus the advanced degree cap. A lot of my clients are Stanford students, and Stanford is on the quarter system, not the semester system. So whereas other universities have graduation dates in the middle of May, Stanford's graduation is always usually the third weekend in June. What does that mean if you're getting your very first master's degree and you went through the master's cap, the advanced degree cap? Well, it means that even if we get all your documentation done early and your H-1B is ready to be filed in May, we should not file it until we have your final transcript showing that you've graduated and received your master's degree. So if anybody's on a quarter system about to graduate with their first master's degree and subject to the master's cap, it's critical to communicate that with your legal team so that that timing window for filing can be, carefully aligned and monitored. And then just another note, selected status does not mean that you have an employment authorization document. There is no sort of work status that automatically gets bequeathed by being selected in this lottery yet. There's still, as you can now tell, a number of hoops that we need to go through to secure the status to work for that individual. Now, what happens when we're preparing the H-1B petition? So this is where I can quickly bore you to tears with all of the things that we will do to support the drafting process, but just so you have a basic overview, because nobody really wants to know how sausage is made. There is a notice of filing process where other people in the company need to be alerted about the proposed wage that's going to be paid to this individual, with in-person postings in the work site. There can also be digital postings. Then we have to get the labor condition application approved was certified with the Department of Labor, which can take a week. But if you're at a brand new early stage startup and this is your company's first H-1B, we have to go through an initial pre-screen process to get your company verified and make sure USCIS will know your company is legit when we get to the filing stage, and pre-authorize it with the Department of Labor. We work with a lot of early stage technology startups, and so that setup process to prepare the company to be able to qualify for an H-1B, even though the company has had somebody in the lottery who got selected, that's just a very preliminary data gathering step from USCIS. There's a lot more that they actually look for to approve the petition. So if you reach out to us, we're gonna, because you would like to initiate your H-1B with Alcorn for somebody who just got selected and you're not our client yet, we still have to put you through our vetting and verification process to ensure we meet all the elements of an H-1B case. Is it a real company with the ability to pay the prevailing wage? Is there a real job offer that qualifies as a specialty occupation under the H-1B guidelines, which just got updated in January? And then does the person really have that amount of knowledge to be able to perform this specialty occupation based on their education or their experience? And some of that can get into really into the weeds of H-1B legal arguments. In Trump 1.0, around this time of year, they suddenly created a ton of requests for evidence for anybody who had chosen the standard occupational code for computer programmer, because they said that computer programmers was no longer a job that required a bachelor's degree. Therefore, it did not meet specialty occupation requirements for H-1B, and therefore they highly scrutinized if any of those people would end up getting their visas, and many did not. So this is why we're always staying on top of all of the latest information from USCIS, because it's important to stay nimble and agile to give everybody the highest chance of actually winning. So this is some of what we do in our process. And obviously we're going to need a ton of information, background documents. Some of you who've already retained us have graciously given us many of those materials, which will be very helpful and streamline the process for you moving forward. But in general, we really, really want to engage in proactive planning, stay adaptive, and be ready for this, thorough vetting environment that immigration is today. And when we do that, we experience that our clients continue to have an extremely high success rate. So that's kind of what we're seeing in the field out there. Now, as many of you on this webinar are employers who are, maybe this is your first H-1B that you've ever done. Maybe you're chief of staff or head of people ops at a really exciting new startup. And because one of your engineers is on OPT, you got suddenly thrust with the responsibility for figuring out their H-1B in the lottery, and this is your first time. So what do you need to know about this process for your company? Well, this is an employer petitioned process. So the company is responsible for filing the documents, for getting the job approved, and then it has the benefit of being able to employ the beneficiary, who is the international team member who's going through the immigration process. So the company has to make sure that all of the immigration forms are complete and accurate, that the information that is included is correct. We need somebody from the company to sign. That can be the CEO, the CFO, the COO, the people ops, HR. There's a number of common roles that people would be responsible for this in. And also, there's compliance requirements for the Department of Labor, which is part of that LCA attestation process and the notice of filing that we walk you through when we're preparing the H-1B. And this is, there's two strands of thought of protectionism and immigration law. So in the PERM process, which is the green card, that's where the government and the laws are concerned about protecting American workers from overcompetition. But in this LCA process, this is where the government decided to be concerned about protecting the international workers from unscrupulous employers. So there's a number of requirements in this about protecting your future hires. Now, yeah, and there's a number of rights and workplace conditions. So some examples of that would be the employers must be the payors of any sort of legal process for H-1B except for premium processing. So if you engage with Alcorn, the company has to be the payor. It can't be paid by the employee. It can't be docked from the employee's wages or bonus. The company has to pay both Alcorn's for Alcorn services, which I'll describe a little bit later what our rates are, as well as the USCIS filing fees, which are typically $2,010 for a company with under 25 or fewer employees, about $4K if you have more than 25 employees, plus additional fees if your company has more than 50 people on payroll on H-1B or L-1 visa status. And then premium processing, which is optional and most companies choose to pay it, is $2,805. And the benefit is instead of waiting 3, 6, 9 months for an H-1B decision, you can get that decision in 15 business days, which is about 3 calendar weeks. I always have to make sure I'm stating that correctly. Okay, so now how do we navigate any challenges that might come up along the way? Well, the first challenge would be if you don't hire us on time and you want our help. So as I said, please reach out. The second would be if we have a challenge getting all the right evidence together, or if there's a company formation issue, or if maybe it's a startup and the founders just incorporated on Clerky or Stripe Atlas, and we have to go through some additional hoops to ensure that it's a legit, fully registered company from an immigration perspective. So we can walk you through all of that. There's also requests for evidence that come from USCIS. These would typically happen about 2 weeks after filing or 3 weeks after filing if they do come up. Because at Alcorn, we take this proactive planning approach and we're adapting to, and creating practices to help our clients thrive in this more thorough vetting environment. Our RFE rate has always historically been below average. However, there's certain things we can't control, like will there be an equivalent to a computer program or memo this year? But we have some practices in place that help our clients have high chances of approval, even if there's some, weird job that gets the spotlight thrown on it this spring. And then there are alternatives if the petition is denied. I'm not going to go into that too much today, but I do have a webinar on that very topic in 24 hours. I decided instead of lumping it all into one massive webinar, that I would do 2 webinars 2 days in a row. So if you want to focus more on the alternatives beyond H-1B or next steps beyond H-1B, or if you have a friend or somebody else in your company who was not yet selected, please join me in 24 hours. I will put that link in the chat window right now. You can share this link with a friend, but in 23 hours and 33 minutes will be my what to do if you were not selected in the H-1B lottery. And that is primarily focusing on alternatives such as the O1 visa, the TN, the H-1B1, Day 1 OPT and CPT, EB-1A green cards, EB-2 NIW green cards. So I'll be happy to go into that more tomorrow. Okay, next up, what happens after your H-1B gets approved? Okay, well, this is where I actually want to double click and talk about international students on F1 and what cap-gap is. So if somebody is on F1 status and they had regular OPT and they study law and it's not a STEM degree and they're never going to get STEM OPT, then they would need cap-gap if they got selected. And if somebody has a STEM degree and they're eligible for STEM OPT, then they would need cap-gap only at the very end in their third and final year of OPT. So right at the very end of their STEM OPT. So it's only a protection for people who are absolutely at the end of whatever OPT they have access to. So cap-gap states that if somebody's final year of OPT is about to expire, as long as the employer files the new H-1B petition with USCIS and USCIS receives it while that person's work permit is still active, not while they're in their grace period, but they still have to have a valid EAD, then the person benefits automatically from the cap-gap protection. And so they are automatically authorized with no USCIS documentation except for the receipt notice to be able to continue working for that employer until and now beyond the October 1st start date, up and until they receive an H-1B decision from USCIS. Now, if the H-1B is denied, you have to leave. But if the H-1B is approved, then whenever you receive the approval, you then shift the I-9 verification based on the H-1B. So this used to only exist until October 1st. And when people didn't pay for premium processing, if the government took longer than October 1st to do a change of status, these individuals would be stuck in the United States, unable to travel internationally and unable to work. So they would just be here existing, waiting, which was a very unfortunate situation for people to get stuck in. They've extended the cap-gap provisions under the H-1B modernization rule. And I believe they now last for another 6 months. So I still like premium processing because I think the peace of mind is worth it. But for whatever reason, if you're not using premium processing, that extends cap-gap now beyond October 1st. So there's a more ample time period to have that protection beyond the October 1st start date. So if you're engaging with Alcorn for a beneficiary who needs cap-gap protections, we will screen for that, but please proactively bring it to our attention because, for example, another school, Berkeley, UC Berkeley, their students often have their OPT or STEM OPT ending around May 15th. And so for them to get the cap-gap protection, even though we have until June 30th for the H-1B deadline, we actually have to file the H-1B earlier by their May 15th EAD expiration to ensure that they have the cap-gap protections. So there's just many moving parts to keep in mind here. Now, another important thing that I want to talk about, in addition to, there's compliance. You got to make sure that you're doing I-9 verification. If you're a E-Verify employer, you have to make sure you're using E-Verify consistently for all hires. You need to train your hiring managers on these types of proper procedures. Additionally, the employer is liable for the return ticket back to the home country if the person is terminated on their H-1B. And then additionally, the employer has to affirmatively inform USCIS that the H-1B has been withdrawn at the end of any employment. So keep that in mind from a compliance perspective. Now, if somebody is physically outside the United States and they want to come in, that is called consular processing. Historically, okay, so I became my dad was an immigration lawyer, so I've been doing H-1Bs like forever. But I officially became a lawyer in 2008 during the Great Recession. And at that time, we didn't use all of the 85,000 H-1Bs that year. And you could get H-1Bs like 6-8 months into the fiscal year. There was no lottery. So at that time, people were hiring folks who were international, getting them their first H-1B visa and helping them come in. That's less common these days. But of course, if you do have a candidate who lives in India or Brazil or who's Ukrainian and abroad, and that person gets selected, and they're not here right now, they would need to go through a visa stamping process to get the visa and come in. Somebody's physically in the United States, and this is something that my team, this is part of our package, people have travel questions, but I'll just share our general approach to travel right now. We're only recommending essential travel. There are very many questions that arise regarding what's happening right now at the borders and airports and consulates. And so I believe that it is the most prudent and conservative and cautious and appropriate course of action to limit any non-essential travel. So in the past, I've had clients like in the beginning of the Biden administration who would be like, I got selected. I want to activate my H-1B, but I got to go to my friend's wedding. So is it okay if I do consular processing instead of a change of status? I would recommend rethinking weddings this summer, just until we know, what the situation is actually going to be like. Another situation is people from India or China who are trying to preserve all 3 years of regular and STEM OPT before activating H-1B to give them a longer time window to deal with perm and securing a priority date. And although that strategy was okay, I don't think it's the most conservative. If you're physically in the US, I would recommend proceeding with a change of status instead of applying for consular and delaying picking up the visa stamp. I believe there's, enough uncertainty already. We don't need to create any more service area for that. So all those questions are things that our team will support you with later. Now, we do offer a number of solutions. We do have a lot of founders this year applying for H-1B for the first time for their own companies where they're 100% owners. And we've been doing this for years, but this was the first year where we had the official blessing of the administration through the H-1B modernization rule. So, please reach out to us for all you startup founders, as there's more legwork at the beginning for us to ensure that your company is fully compliant and legit so that you have the best chances of approval. Now, just so you know, and I'll be talking about more of all this tomorrow, but I try to be as proactive with offering legal innovations and offering comprehensive strategies for folks as possible. So I do have the online class, Alcorn Academy, which is now complimentary. Over 1,000 people have enrolled. It's very exciting. Many are now green card holders, and it's super cool to see that they started their O1A, EB1A, EB2, and IW journeys there. Legal launch, if anybody wants EB1A or O1A or EB2 and IW assessment and evaluation, we have a 4-week comprehensive program for that with a number of meetings with our teams, culminating in a case strategy session with a gap analysis on where you need to build out your evidence. So that's legal launch, that's on our website. And the H-1Bs, sometimes people have questions about concurrent H-1Bs or part-time H-1Bs or, cap exempt H-1Bs. I'll talk about that more tomorrow. But I think for all you right now, just focus on the H-1B. That's the one thing. Getting picked in this lottery is such a blessing. It gives you a dual intent status that allows you to pursue a green card pathway and travel internationally throughout. And if you're married or getting married at some point and you go through the green card process, then your spouse can get a work permit and it's indefinitely renewable while you're waiting for a green card. So, I've had a person who I've been consulting with on an individual basis reach out yesterday and say that his employer had been drafting an O1 with their immigration attorney through the company, and the person got selected in the lottery, and the employer gave this individual an ultimatum saying, all right, well, I'm only doing one pick. Do you want the O1 or do you want the H-1B? He's like, what should I do? And I'm like, well, there's a lot of advantages to both. So, but if you can, I think it's best to do everything, as Napoleon said. So if you have this chance of being selected in the lottery, I would definitely recommend you proceed with filing the petition. Okay, now I'm gonna talk briefly about if you reach out to us for a consultation and what typically happens, and then also kind of the revised thing that we're doing right now to be able to support you, and also our pricing. So typically when a new candidate reaches out to Alcorn, we have them complete a comprehensive questionnaire where we screen them for a variety of immigration flags. For example, if somebody had a J-1 visa in the past and they're subject to the 212E 2-year foreign residence requirement, we might not be able to file the H-1B unless you're on a country that just got removed from the list. So there's like a bunch of legal nuances that we're looking for, right? So typically, we would have I would communicate with the employer on, what are they looking for? What's the role? What does the person need to be able to do to support the company? We would screen for the candidate with their resume, a questionnaire like this. We would put together options. This would all happen in a consultation format. And then we would share our client services agreement with the company. And that includes our fee schedule with our flat fees and timing for every case type that we do. There's like 65 or something. It's a lot. I try to keep it as simple as possible. But everything we do is on a project basis, no hourly work. I try to keep it simple and, the essentials. So we are changing the process because I would like to ensure that we are able to help all the employers on this webinar to be able to jump in and represent your company on these H-1Bs for your candidates who got selected. So what we are now doing is, if you email hello@alcorn.law, tell us about your company, tell us about who got selected, how many visas you need. My team will do our intake process to ensure that your company is qualified, the job role is qualified, and your candidate is qualified. And I'm normally very controlling and I want to meet with everybody, but assuming that you pass those screening mechanisms, we'll be happy to consider taking on your case without the bottleneck of me being needing to get on my calendar to be able to talk to you. So I'll share a little bit about our rates. Okay, and it's a little bit complicated, but I'll try to make it as clear as possible. So the company is always going to pay the USCIS filing fees. We will calculate those based on your headcount. Additionally, you have the right to choose premium processing, yes or no. If the company doesn't want to pay for it, the beneficiary can pay for it. So that's the government. It usually ends up being $2,000 to $5,000 for most of our clients, depending on which aspects you pick. Separately from that are our legal services. We get retained to prepare and file the petition. If there is a request for evidence, that is a separate process where you would retain us to engage. So both have a flat fee project basis model. We have standard fees for initiating H-1B now. The RFE process is, we have to evaluate what type of RFE we're getting. Is this a 1-hour RFE? Is this a 15-hour RFE, right? And so our rates, our flat rates kind of scale with the volume of labor that needs to be done. Our highest price for an H-1B now for the lottery is $6,250. That is our rate for the very first H-1B for a brand new company that's never done an H-1B before, which did not previously work with Alcorn for this registration. If you're here because you worked with Alcorn for the registration, you would have paid one of two types of fees. One would be our normal or our early bird rates if you were proactive last year to start the registration process. We fully credit that to The future H-1B service fee, which as I mentioned is $6,250 if this is the company's very first H-1B, or $4,950 if this is your second or more H-1B for the company. That's typically how this works. And then if you hired us like 2 weeks ago and you paid a late fee, that does not get credited to the fee. So our team will just tell you and give you a breakdown, but I just wanted to generally explain that's how our pricing is right now. That's how I've designed it. I believe it's the fairest and clearest way, and we'll give you a detailed quote for anybody you're interested in. But I wanted to make sure you had the details, as I might not be able to get on a phone call with each of you in the next 2 weeks, which is when I would like you to engage with us if you would like our help to meet the June 30th deadline. Okay, so now we are going to go to our Q&A. Very excited because I see lots of wonderful questions in the Q&A panel. And I'm just going to start answering those. I can ask you. That would be fun. And if you have more questions, now is definitely the time to add those to the Q&A panel. I believe we have enough time for some more. So if you have anything you need, please do ask right now. I'll be excited to answer those for you. Okay, so here's a question. Is OPT getting eliminated? Would it affect folks who are already approved with OPT and STEM OPT? Just got a sip of water. Okay. First of all, probably not. Second of all, there are no concrete, real plans where anybody's actually getting STEM OPT eliminated yet, as far as I know, as of Wednesday, April 2nd at 12:44 p.m. Pacific time. There certainly was a lot of political rhetoric last year about doing this, but as far as I've seen, U.S. Citizenship and Immigration Services and Immigration and Customs Enforcement and DHS, Department of Homeland Security, nobody has yet issued any sort of proposed regulation to reform the OPT process. And that would be the legal requirement to do this. It would have to go through the Administrative Procedures Act. It would probably take more than a year, and there would probably be litigation. So although it's completely speculative, because as far as I know, nothing's been released, so I don't know how it would be written. So I don't know if it would affect folks who are already approved. The chances are extremely unlikely. And especially if you got selected in this year's H-1B cycle, the chance of anything affecting OPT or STEM OPT by October 1st, 2025 is almost 0. So I think you're fine. Anonymous would like to know if it's possible to change employers after being selected in the H-1B lottery. Yes, the beneficiary is allowed to transfer. My recommendation is typically to give it at least 3 pay cycles after October 1st before making any changes, so that the H-1B is not jeopardized. But you know, I also represent employers, so just please keep in mind that employers go through great lengths to put you into the lottery, and they appreciate if you can, you know, do them a solid and stay with them at this point. What do you recommend, and what is the best course of action to speed up the visa process and enter the US as soon as possible? Well, if you're on an H-1B and you're outside of the United States, you're only eligible to enter up to 10 days before October 1st. So you can come in on like September 20th is the earliest possible date. So if you're concerned about a potential country travel restriction that might be coming, waiting for an H-1B visa would not be the way to navigate that. I have had in the past clients who have entered the United States in B1, B2 visitor status on a business trip in the 6 months prior to October 1st. So we're in that window right now. And then they've been able to file a change of status to H-1B. But they would have to be physically in the US by June 30th to be able to pull that off. And in the Trump 1.0 administration, an important thing to keep in mind is that if somebody got a brand new visa and then came in and applied for a change of status within 60 days, they could end up having their visa revoked. So that would prevent further international travel. So there's a lot of factors to keep in mind there. Let's see what's going on here. See, somebody sent me a link. Okay, somebody shared that there is a bill to eliminate OPT that was put forward 2 hours ago. Okay, look, it's just been 2 hours. I didn't know yet. Oh my God. Okay. Let's see. I'll have to take careful note. This is probably something that I will be addressing in a video or social media if it seems important enough. Obviously, I'm not familiar with this yet, but I'm gonna let my team know. So I'll be looking into that, but at first glance, not having read it, Representative Gosar, a Republican from Arizona, introduced this bill. Oh, okay, March 25th. It was referred to the House Committee on the Judiciary. It would amend the F1 section in the Immigration and Nationality Act to state that no person on F1 is able to get any OPT unless Congress affirmatively passes OPT. The chances of this ever passing are extremely, extremely small, and it would probably take a very long time, and it would probably be eliminated, or it would definitely be litigated. So, okay. So I think it's in the category of interesting, but not imminent. And I would say even, not very likely. There are a bunch of pro-immigration Republicans who understand the importance of this program. Okay, next up, I'd like to make my decision about filing a petition or not as late as possible. Are there downsides to filing on the last day, June 30th? How long does a lawyer need to prepare? I mean, I don't know why you wouldn't apply. If you do it on the last day, you risk the whole thing getting botched, and then you've put in a ton of time and effort, and then there's like a UPS failure. We can e-file now, but typically it takes us 6 to 8 weeks to do a good job at an H-1B petition, ensuring that all the bases are covered, especially this time of year, and with this more thorough vetting situation. So if you're going to hire an attorney, you probably need to figure it out by the beginning of May, but we might be needing to charge additional fees at that time to deal, because I don't have infinite capacity. I run a services business with humans, and as great as all these technologies are, it takes real caring, thoughtful people to put this together in the correct way to ensure you have the highest chance. Next up, if my passport will be expiring soon, this July, after the filing petition deadline, and if my spouse's passport has already expired this March, should we renew our passports right now? Yeah, if you're in the US, it's not necessarily required, but it's still a best practice, and probably lines for passport renewals, whatever country you're from, are probably increasing just given the immigration environment. So I think it's a best practice, especially if you need to travel to do visa stamping. Do you need to leave the country and attend a consulate to finalize the H-1B like you have to for the E3, for example? Okay, no, it's different, sort of. As I mentioned, you can stay in the US and just do a change of status, and the petition, if it gets approved, will take effect on October 1st, and then you're allowed to live here and work here for 3 years based on these terms of employment. With international travel, If you do a change of status with international travel, then when you leave, in order to get back in, you will need to do a visa stamping interview at a consulate to ensure you have permission to get back into the country and then continue working on that H-1B petition again. The H-1B is a little bit different from the E3 because the E3 is this weird special thing for Australians. You don't need an approved I-129 petition from USCIS to get an E3. You just bring your labor condition application and go to the consulate and you get your E3 visa stamp. With the H-1B, you have to get the USCIS approval and bring it to Australia to get the visa. Can I apply to F1 STEM OPT and use that to travel in the summer over the summer under that visa? I do not recommend it. If you were just selected in the H-1B lottery, and you're on F1 and STEM OPT and your F1 visa expired and you want to travel, I don't think it's safe because at this point, I saw people in Trug 1.0 on STEM OPT that got denied F1 visas towards the ends of their OPT or STEM OPT because the visa officer assumed immigrant intent. And so with a job lined up and an H-1B approved, your F1 could be denied and then you would be stuck outside the US until October 1st and you would have to do an H-1B visa stamp. So I don't think it's wise. How do fully remote jobs affect the wage compliance for the H-1B? We list all the work sites. This is part of our process to figure out what the prevailing wages the company needs to pay the individual. If somebody is fully remote and they're living in, Arkansas, maybe Bentonville's slightly higher, but probably Arkansas is still a lot lower than California, right? So you just have to, the company has to pay the person the wage for their work location. So if they're working from home in a state with a lower wages, then you would have to comply with those lower wages. In the pandemic, I had a lot of clients moving to obviously Texas, Idaho, kind of, in beautiful random places in the middle of the country. If we did the registration process with Alcorn, do we need to do anything additional to start the petition process with them, or does it continue? You should be receiving an email. You should have, maybe you're supposed to get it yesterday from my team. I hope you got it. If not, you'll get it today, but just let me know. We need you to reply to that email and just confirm, yes, I want to proceed. And it also asks, do you want premium processing? Are you good with a change of status instead of consular processing? And does this individual have a spouse or any children that need to be included? So once we have those details, we're happy to initiate your case for next steps right away. Are level 3 or 4 wages really important for a successful H-1B petition? It depends. This is part of that nuanced legal strategy that we do based on live updates of what's happening in the world. It is a holistic process. So not all of our clients need level 3 or 4 wages. It is more important if the job does not seem that professional. So if you're like, it just depends. If you're maybe in a field like marketing or business administration, where it's a tougher argument for us to prove that it's a specialty occupation, having higher wages might help. But if you're in an extremely technical, nuanced field where everybody absolutely has, a master's degree, then having those wages aren't as important. So it's a complex strategy. Okay, we covered the bill. If the STEM OPT is valid until December 2025, would you suggest to do premium processing for the H-1B petition? If you don't need to travel internationally and you want to save the money and you're a low anxiety person, then it's totally fine to skip it. You could always add it in later if you change your mind. I got selected through a consultancy and they're currently looking for a project for me. Is there anything I should be cautious about? Yeah, they can't bench you, so you're not allowed to not work after October 1st. Once the H-1B is approved, you are allowed to transfer it. You are allowed to do a concurrent H-1B for part-time work or full-time work in another place. But the main thing is just to ensure that that initial H-1B gets approved. Alcorn's fees, so the government fee is separate. Our regular rate, if your company is doing a normal H-1B for a normal employee and you've already had an H-1B before, is $4,950 minus registration fees, but not late fees. So $5K, and then if it's the very first H-1B, like at a startup, it would be $6,250 minus anything you paid before, as mentioned. If you got selected through your own startup, but now you have an offer from a big company that you want to take, what is the best course of action? To get the H-1B approved through your startup, get 3 paychecks in October and November, and then ask the company to do a transfer in the future. You have to activate this H-1B and get it approved. The other option, which is more risky, is you get it approved this summer for consular processing, and you convince the company's immigration lawyer that on October 1st, they will do a transfer petition for consular processing, or even a change of status, but that's more risky. But you should align now with the recruiters and the immigration people from the company where you want to work to make sure it's a mutually viable strategy. Because not every law firm has the same practices regarding H-1B filing, risk tolerance, familiarity with startups. So they might not feel comfortable. They might want you to start sooner and lose your H-1B chance. So these are all items for discussion. If the petitioner is a nonprofit, yes, there is a lower fee with USCIS. I can tell you what those are right now. I have a detailed spreadsheet. And I have 1 more minute. Okay. H-1B nonprofit cap. The fees for nonprofits with less than 25 employees are $960, but premium processing remains the same, $2,805. The minimum wage, happy to do a consultation with you. That's complex. We need the job description. We need a lot of details. It's legal analysis we offer as part of our service package or on a paid consultation call. If somebody moves abroad but remains with the same employer, do they forfeit the H-1B or could they move back within the 3-year term? You can move back. You need a valid visa, you need a valid approval notice, you need to be within, working in the same sort of capacity. The employer would probably want to give you a letter saying the offer still stands, but that's very doable. People do that. Okay, last 3 questions. Got H-1B lottery, F1 OPT ends in July. Will you need to apply for STEM OPT? Yes, absolutely. If you have access to STEM OPT, even if you got selected in the lottery, you must get STEM OPT. You will not qualify for CAP-GAP, and you have to make sure you're maintaining valid status on October 1st when the change of status to H-1B takes effect. Can I elaborate on extending the H-1B visa to use up the STEM OPT 2 years? You would basically have the company set up your H-1B petition as consular processing, and then you wouldn't go get the visa stamped, and you would just keep working in the US on STEM OPT, and then later you would go to a visa stamping interview. But that casts doubt on the legitimacy of the job offer and could jeopardize your future visa access. So I don't recommend it right now. And then last question, following up on the passport expiration question above, we're staying in the US for a change of status. STEM OPT ends March 2026. Do we need to get our new passports and submit the documents for the H-1B petition by 6/30? I believe the answer is no, but I'm not the person who prepares the H-1Bs in my firm right now. So if you're hiring us, we're happy to figure it out for you. If you need a paid consultation, we can research it for you. I believe the answer is no. Okay, so that's it. Thank you so much for staying with me. I really appreciate everybody and your amazing questions. Please reach out to us, hello@alcorn.law, or give us a call, 855-546-0015. Operators are standing by. All right, have a wonderful day, everybody, and thank you so much. And if you need more inspirational tips about other immigration options, tomorrow is the day. And that'll be in 24 hours. I shared the link. It's on our website, what to do if you were not selected. And I'm so glad I could be helpful to all of you. Thank you so much for your positive, supportive comments. And we look forward to supporting you. So please keep in touch. Thank you.